Listeners, welcome in the classes of the company law. We have studied the four units of the company law, which are company and its forms, incorporation and its consequences, financial structure of companies, management and control of companies. Now, in this unit, we will learn about the recent developments and emerging trends in the Companies Act. In this, we will learn about the amendments to the company law, recent cases, and the emerging trends in corporate governance. So, the Companies Act 2013 replaced the Companies Act of the year 1956. The Companies Act 2013 is a comprehensive act and it is uh, enacted to replace the Companies Act of the year 1956, and this act establishes some new concepts in the company law and elaborates the procedure envisaged in the earlier acts. So in this uh, session we will learn uh, about some features of the Companies Act which have been amended and the new amendments of the Companies Act. So the Companies Amendment Bill 2019 was passed by Lok Sabha and it has introduced some uh, amendments in the Companies Act of 2013. So this is the latest amendment in the Companies Act of the year 2013, which has been amended in the year 2019. The Companies Act 2013 replaced the Companies Act of the year 1956, which was recommended by the Bhabha Committee. Uh, so this Companies Act has been amended multiple times in the history, and this act is of the year 2013. Companies Act regulates the formation and functioning of corporations or companies, and the law related to companies uh, is in force since the British rule, that is the year 1881. In the Companies Act of the 2013, the offences have been defined, and, and the offences uh, are of two types, which are liable to penalty and which are punishable in the different kinds of punishments. The punishments which are offences which are punishable with penalty, they are adjudicated by the registrar of the companies, and the offences punishable are dealt with the National Company Law Tribunal and the trial courts. In this, there are two types of offences which are compoundable offence and the non-compoundable offences. Compoundable offences are those which uh, are punishable with imprisonment or fine or both, or adjudicated by uh, NCLT with the maximum fine of 25 lakh rupees. Other features which has been enacted with the Companies Act 2013 are in the limitation of the members in the private companies. Earlier, the as it is there is minimum number of prescription for the private company which is 2, and the maximum number of members which can be in a company, in a private company, is 200. Earlier, before the 2013 Amendment Act, the maximum number of shareholders in a private company was limited to 50. The concept of one person company has been incorporated, has been instituted in the Companies Act of 2013. Earlier, in the earlier uh, Act of the Companies Act 2013, there were no provisions related to the one person company. CSR, that is corporate social responsibility, has been made mandatory, which is to show the importance of a benefits of a company to the society. It is a duty of a company to share its profit in the society. It is a had been made corporate responsibility towards the society to follow the mandate, and there has been uh, defined and specified provisions uh, for who have to make the CSR committee and who have to do a CSR. In this, the minimum benchmark is the 5 crore profit earning company, or the 500 crore company, wealthy company, or the 1000 crore turnover company. In the Companies Act of the 2013, the concept of dormant companies have been introduced. The dormant companies are those that have not engaged in business for 2 years consecutively. Companies Act 2013 also introduced the National Company Law Tribunal. It is a quasi-judicial body to adjudicate the issues concerning the companies. It replaced the earlier established Company Law Board. It provides for the self-regulation concerning disclosures and transparency rather than government approval-based regimes. Companies Act 2013 has been made technology friendly. The documents have to be maintained in electronic form. Another feature of the Companies Act 2013 are that official liquidators have adjudicatory powers for companies having net assets of up to rupees 1 crore. The procedure for merger and amalgamation have been made faster and simpler under the Companies Act of 2013. The provision of cross-border mergers has been allowed in this act, and the cross-border merger can be done with the permission of the Reserve Bank of India in this new Companies Act of the 2013. The concept of one person company, this is a new concept which has been instituted in the Companies Act. At least minimum number of requirement of directors in the company has also been instituted in this act of 2013. Earlier it was left blank. In this new amendment, there is a requirement of minimum 2 number of directors and 2 number of shareholders for a private company has been defined. Uh, Statutory provision has been made to include an independent director in the board of directors. And there will be a one at least one independent director which has to be elected from the group of the shareholders. There are companies which has been prescribed for different classes, and the provision has been made for the women empowerment under the Companies Act. In this, there should be a minimum one number of women director in the company, and the provision regarding the residence of a director has been specified, which says in the board of directors at least one director should be a resident of India, which means that director should have been in India for the at least 182 days, that is 6 months in a year in the last calendar year. This act also provides for extra legal safeguards regarding the article of association. This act also mandates for at least 7 days of notice to call for board meetings. This act has defined the duties of director and this act also defined the duties of a promoter and the key managerial personnel. The Companies Act 2013 is a rejuvenated legislation regarding the company. It is a wholesome act. It has many features. It also provides that there should be a rotation of audit firms and auditors for the public companies. And this act also prevents auditors from performing non-audit services to the company. In the case of non-compliance, the company has been made liable, and the liability is of two kinds, that is civil and criminal liability. In the civil liability, the company can be punished with the fine or will be liable to uh, fine up to multiple of times. And in the criminal liability, the person behind the curtain will be liable to be punishment, and the punishment may be of imprisonment of either kind. The whole process of rehabilitation and liquidation of a companies in case of a financial crisis has been made time bound, so the shareholders does not face uh, does not have to face the loss in the company. The one of the best provision which has been introduced in the 2013 act is the mandatory formation of a CSR committees, that is the corporate social responsibility committees, and to formulate the policies regarding the corporate social responsibilities of a company. And there has been defined financial structure for which the companies uh, following that uh, rules and regulation will have to form the CSR committee. The company will have to expend 2% of their profit in the CSR. The listed companies should have at least one director, and one director should represent the small shareholders also. The small shareholder has been defined in this act. The small shareholders means the shareholders who have invested uh, the value of 20,000 rupees or less. So, uh, when the board of directors has to be formed, there should be an elected director from the small shareholders. There is a provision for search and seizure of documents and investigation without the order from a magistrate. So, the power of a civil court has been vested under this Companies Act in the authorities. And the norms has been made strict to accept the deposits from the public. Uh, there has different provisions for the issuing of offer to the public and to the private persons. The setting up of National Financial Reporting Authority has been introduced in this Companies Act of 2013. Due to notification of National Financial Reporting Authority, India is now eligible for membership of the International Forum of Independent Regulators. This act also bars some key managerial personnel and directors from purchasing call and put options of shares of company, and this act offers more power to shareholders. The 2019 amendment in the Companies Act 2013 was passed by the Parliament in July 2019, and these are the latest amendments in the companies. And in this, the provision related the CSR has been broadly elaborated in this. The unspent amount which has not been spent by the CSR committee will have to keep in a special account for the purpose of a CSR. 16 minor offences has been decriminalized under this Companies Act, which are of civil nature. The amount which has been left unspent by the company for the period of 3 years will be moved to the specified fund in the Schedule 7, and this fund can also be transferred to the Prime Minister's Relief Fund. Under the Act, Registrar of Companies can initiate the action suo motu for the removal of a company's name from the register of the companies. If the company is not conducting business operation under the provisions of a company law, the registrar of the companies can initiate action for the removal of the company's name from the register of companies. So, as we knew, the major highlights of the 2013 Act are the maximum number of shareholders in the private company cap has been increased from 50 to 200. The concept of one person company has been introduced. The Company Law Appellate Tribunal replaced the Company Law Board, and the National Company Law Tribunal and the National Company Law Appellate Tribunal has been formed. The concept of corporate social responsibility has been made mandatory. Thank you. Thank you so much for having in this session. So this was all about the company's law in all 5 units. Thank you. You can under if you are interested in the company's law, there are new such roles in the corporate sector which are developing, in the student of a BCom or the LLB or anyone who is interested in the company's law should learn the Companies Act of 2013 and the rules related to the Companies Act of 2013, and this emerging trend in the corporate governance. You will be having a bright career in the corporate law. You can work as an in-house counsel and in the many positions in the companies. So company law is one of the best laws which are pushing the economic growth and the development of the country, that is India, and this is being utilized by the government for the welfare of the people. Thank you. This was all from my side. My name is Pradyumna Sharma. I am an assistant professor in the Mewar University, Faculty of Legal Studies. Thank you. Have a nice day.